we are now recording. It is May 25th, 2016. This is Trust Webinar number 8 in the series. Today, we are going to be going over some case law to get some examples, specifically in dealing with public versus private. You know, you always hear me talk about public and private, public and private. You're probably getting tired of me saying that. All law is either public or private law. I cannot stress that enough. And there is a document while we are studying this document on my website under the Constitutional and Law section. You will find a document that says public and private outline. This outline is something that you should think about while we are reading this particular case. In particular, I want everybody to pay attention to the fact that constitutional law is on the public side. So when you hear references in this case to the Constitution, they're going to be referencing the public. They may not necessarily use the word public. They don't always use the word public. They'll say Constitution or something like that, or some sort of synonym that means public. But and a lot, they're going to be, this whole case is dealing with public versus private. This is very, very important, especially in trust law, because we're dealing with jurisdiction. You're going to need to know the difference between public and private, and I feel like this is a very good case that demonstrates significantly and as close to layman terms as possible exactly what is public and private. This is a Supreme Court case in 1966, Evans versus Newton, 382 U.S. 296. Number 61, it was argued November 9th and 10th in 1965 and decided January 16th, 1966. There was a certiorari to the Supreme Court of Georgia. And eventually this went to the Supreme Court of the United States. All right. And here, Mr. Justice Douglas delivered the opinion of the court. In 1911, United States Senator Augustus O. Bacon executed a will that devised to the mayor and council of the city of Macon, Georgia, a tract of land which, after the death of the senator's wife and daughters, was to be used as a park and pleasure ground for white people only. The senator, stating in the will that while he had only the kindest feeling for the Negroes, he was of the opinion that in their social relations, the two races, white and Negro, should forever separate. The will provided that the park should be under the control of a board of managers of 7 persons, all of whom were to be white. The city kept the park segregated for some years, but in time let Negroes use it, taking the position that the park was a public facility which it could not constitutionally manage and maintain on a segregated basis. Remember, Constitution is on what side? Constitution is on the public side. I don't want you to keep thinking about that. Therefore, individual members of the Board of Managers right here means Board of Trustees. All right, they're up on individual members of the Board of Trustees of the park brought this suit in a state court against the city of Macon and the trustees of certain residuary beneficiaries of Senator Bacon's estate, asking that the city be removed as trustee and that the court appoint new trustees to whom title to the park would be transferred. The city answered alleging it could not legally enforce racial segregation in the park. The other defendants admitted the allegation and requested the city be removed as trustee. So right here we see where the city of Macon was appointed trustee for this park, and their board of managers understood that while this senator in his indenture, which contract makes the law, on the private side, contract makes the law. See, because this was a private will. So over here, his indenture agreement constituted a contract. It's on the private side. All right. So this senator only wanted white people here. Okay. But he appointed public trustees as the trustees. Public people have a duty to uphold the Constitution. In the Constitution, it says, under the 14th Amendment, it has the Equal Protection Clause. So the public trustees could not constitutionally enforce the tenor of the trust indenture agreement of this particular senator. So they called for a meeting and asked to be removed as trustees and to appoint other people who were not in the public to be trustees. All right. So let's continue. It says, several Negro citizens of Macon intervened, alleging that the racial limitation was contrary to the laws and public policy of the United States, and asking that the court refuse to appoint private trustees. Now, I want to show you something real quick. Okay, hold on just a second. Okay, hold on just a second. I got it.
Yusuf, do you mind if I ask you a dumb question while you're looking at something?
Yeah, go ahead. Yeah.
I'm sorry, did you add a day to the trust class and I missed it?
Yes, the class requested that I added a day. I didn't add a day.
Okay, cool.
I was requested
I
that
didn't.
day.
Yeah, I heard that they wanted it, but I never heard the answer, so thank you.
You're welcome. There was too much. Wow, this right here is interesting. Wow. Hold on, let me put this in here too. My throat has been sore lately, y'all. Forgive me. I was looking for this, and I can't believe how difficult this. Hold on real quick, y'all. Hold on.
Yusuf, this is Cherry again. Can you hear me?
Yeah, hold on just a second. Hold on.
Okay.
All right, Chair. What now? What's your question? Cherry.
Sorry, I was muted. It's probably not the appropriate time to tell you, but on the next break, do you have any garlic in your house?
Garlic? Yes, I do.
A clove of garlic?
I sure do.
Okay, so if you get a clove of garlic, it's a small piece, and you peel it but don't nick it, so it's just a shiny piece of garlic, and you put it on the side of your mouth like tobacco or cough drop, and you keep it going back and forth the rest of the night. And if you don't bite it, you won't smell like garlic. You don't even know it's there, and you won't have that cough later.
Thank you. I usually, I know about eating garlic. I usually eat garlic sometimes because of its medicinal. You know, it kills a lot of type of infections and a lot of other things too.
Well, exactly. The reason I'm telling you to suck on it is because it's loaded with all the vitamins, and especially.
We're back recording again. Okay, and what this is the 8 elements that must satisfy for valid trust. And this is what I want everybody to write down, okay? And this will be in the box as well. And it's called 8 elements that must satisfy for valid trust. You have to have intent, capacity, can't violate the statute of frauds, has the legal purpose to the trust, trust must contain property, trust must have legal title, trustee must have legal title, beneficiary must hold equitable title, no violation of rule against perpetuities. All right, you want to remember these 8 things. All right, one of the things is in legal purpose of the trust, I think it is. It talks about methods of trust creation. I mean, this is very good paper right here. As a matter of fact, let's go through it real quick because I want to, okay, trust intent, threshold facts and determine whether a trust exists, the trust intent, splitting of title into legal and equitable portions. Now, we know that in an unincorporated business organization, legal and equitable title are not split. They are merged together and vested in a trustee. All right. Number 2, imposition of enforceable duties of trustee, detailed examination of trust intent, creation of trust, no special language needed, just need to know effect of a trust, must have present intent, easy to prove a trust exists if the beneficiary is given notice. History of trust, used to be called uses. All right. Courts would not enforce trust. They were just honorary obligations. During the 15th century, uses began to be enforceable. D were to avoid duties of property ownership under the feudal ownership system. I passed E passed the statute of uses in 1536 in order to abolish uses. If you are a beneficiary, you have all legal and equitable title. F, legal interest was eliminated, but exceptions were developed, now called active trust, elements of what we today are called enforceable duties. And G, need to have imposition of duties, split of title, must have a split, cannot have both people holding both halves. Only combination that won't work is same person as beneficiary and trustee. All right, that's the only one that won't work. The same person cannot be the beneficiary and the trustee. All right, now merger, when the 2 halves come back together, that's called the doctrine of merger. Let me put that right here, doctrine of merger. All right, see, distinguishing trust from legal relationships. People would often rather be in a trust relationship than other relationships. All right, that's why most people want to do business under a trust. That's true. All right, because they are enforceable duties, better statute of limitations, and more methods of trust creation. 1, times of creation when you're alive, when you're dead. A, while settler is alive, inter vivos, a living trust created during settler's lifetime. Non-probate assets, creation of inter vivos trust, distinguish between them by seeing what is done with legal title, keep the title and transfer the equitable title, blah, blah, blah. And I'm not going to read all this, but I wanted to point out this right here, because one of the things in this legal purpose is it cannot violate public policy. This was one of the reasons why I brought this up. You need to know this because when we go back to the case that we are reading, which is Evans versus Newton, you'll see right here that there was a third-party intervener. The third-party intervener were several Negro citizens intervened. Okay, what is intervene? Intervene is rule number, write all this down, 24. All right, Federal Rules of Civil Procedure, intervention. When you can intervene in a case, if you have an interest in the case, you can intervene. You need to be very familiar with Rule 24, intervention of right. On timely motion, the court must permit anyone to intervene who is given an unconditional right to intervene by a federal statute or claims an interest relating to the property or transaction that is subject of the action and is so situated that disposing of the action may as a practical matter impair or impede the movement's ability to protect its interests unless existing parties adequately represent their interests. And that right there is what you're doing with your straw man. You're coming in as a third-party intervener. Okay? Very important rule for you to know, Rule 24 of intervention. So right here, when you're reading this, when it says several Negro citizens of Macon intervene, that's what it's talking about, a Rule 24, third-party intervention. Now, alleging that the racial limitation was contrary to the laws and public policy of the United States. That's why I was bringing up this right here, because a trust cannot violate statute of frauds or its legal purpose. It cannot violate public policy. All right, so that's what they were claiming. That public policy is that it got to be in accord with the 14th Amendment, which is the Equal Protection Clause. All right, so they cannot discriminate in the public. You cannot discriminate. In the private, you can discriminate as much as you want. Nobody can say anything. If you want an all black or all white club and you want to exclude another race, you have every right to do that. No one can say anything. As long as it is 100% private, they are not receiving any public funds or are connected with the public in any way, you can do whatever you want to do. Now, let's look at what the Negroes was talking about right here. It was like what they was upset about. Several Negro citizens of Macon intervened, alleging that the racial limitation was contrary to the laws and public policy of the United States, and asking that the court refuse to appoint private trustees. Thereafter, the city resigned as trustee and amended its answer accordingly. Moreover, other heirs of Senator Bacon intervened, and they and the defendants, other than the city, asked for reversion of the trust property to the Bacon estate in the event that the prayer of the petition were denied. So, this park has been placed in a trust, and the tenor of the trust stated that it was to be for whites only. We have public trustees, which violated public policy, which is in accordance with the Constitution, because the Constitution is public policy. So all these city officials, they over here in the public, they can't violate the Constitution. All of them are taking oaths to uphold the Constitution. The Constitution contains the Equal Protection Clause, and yet now they've been appointed trustees of a private trust wherein an individual is discriminating against another race of people, something that public trustees cannot do. So they are attempting to resign, and now you have some Negro citizens who are intervening, saying that they are violating public policy, and now you have the heirs of the Bacon estate who are coming in, and they see all this going on, and what they're saying is, okay, well, if the trust cannot function or do what the trust was designed to do, then we're requesting that the trust be returned back to us. The park be returned back to us. That's where we're at right now. All right, anybody got any questions so far? Anybody confused where we're at? Okay, so let's look at what the court, okay. The Georgia court accepted the resignation of the city as trustee and appointed 3 individuals as new trustees, finding it unnecessary to pass on the other claims of the heirs. On appeal by the Negro interveners, the Supreme Court of Georgia affirmed, holding that Senator Bacon had the right to give and bequeath his property to a limited class, that charitable trusts are subject to supervision of a court of equity and the power to appoint new trustees so that the purpose of the trust would not fail was clear. The case is here on a writ of certiorari. Okay, so now it went all the way to the Georgia Supreme Court, and they appealed it from the Georgia Supreme Court to the United States Supreme Court. Okay, the Georgia Supreme Court affirmed everything that the lower courts did. The lower courts, what they did was say, okay, well, we're going to get rid of the public trustees and appoint private trustees. Now, end of discussion. Nothing else to discuss. But the Negro interveners are like, no, well, we can't use the park. No, that's not right. So we're going to appeal. So now that's where we're at. We're going to look at, okay, well, you know, the Georgia court said they have the right to do that. Now, normally, under normal circumstances, you probably would have a lot of black people picketing and protesting. I would not be one of those black people that were picketing and protesting, having my ass on national television looking like the biggest damn fool on planet Earth and representing all of my people and everything, because none of us know not a lick of trust law. We don't know any law, period. We don't know the difference between public and private. We just think that somebody's discriminating against us and these people should be able to do something about it. Isn't that what would probably happen today? Tell the truth. We'd be all on TV picketing and protesting, and in the end of the day, these people were well within their rights to take their land, their private property, and have it administered however they want to, as long as that was done privately. Where they erred is giving it over to the city and having the city do it. Now, here is where the discussion gets interesting, because the Supreme Court judge is about to conduct a class right now. He's going to take everybody to school. All right? This right here. He's going to take everybody to school. Pay close attention to this part. Pay very close attention to this part. There are two complementary principles to be reconciled in this case. One is the right of the individual to pick his own associates so as to express his preferences and dislikes and to fashion his private life by joining such clubs and groups as he chooses. So you can fashion your private life however you choose, as long as you don't infringe upon somebody else's rights. All right? Like the public. Remember Hale versus Hinkle. Does anybody remember what Hale versus Hinkle says? I want somebody to answer this question. I want somebody to pull up Express Trust under the Don Quixote, and I want you to find that and post it in the chat, that Hale versus Hinkle, where that judge was talking about public and private. But right here in this first sentence, this judge, this Supreme Court justice tells you that you have the right to fashion your private life however you wish. Now, that's the private side. Okay, now let's talk about the public side, which is right here. The other is the constitutional ban. Notice, nowhere in this sentence does this judge use the word public. Well, what does he use? He uses what word? What is the operative term that we're looking at that will let us know that this judge is referring to the public? Remember this. Constitutional laws on what side?
Constitution.
Constitution. So, even though you don't see this judge use the word public in this sentence, all right, this is a synonym for public. When you see this word, when they start talking about the Constitution or anything like that, they're talking about the public. So on one side, he's talking about the private. The other is the public ban and the Equal Protection Clause of the 14th Amendment against state-sponsored racial inequality, which of course bars a city from acting as a trustee under a private will that serves the racial segregation clause. Now, so what that means is you can't be a private trustee if that trust is asking you to do something that's going to violate the Constitution. All right. So right here, this is public. This is private, and this is public. Then he gives us a case citation, Pennsylvania versus the Board of Trustees. It is a case, and I'm gonna save it in your just in case y'all want to read it. Later on. And put that in your box for you. All right. And there it is. There is the Hale versus Hinkle. Right there. Thank you for signing that. Somebody found it. Hale versus Hinkle. Regina Gordon, thank you very much. You're a gentleman and a scholar. All right. You found what I was looking for. No, you're a lady and a scholar. I take that back. All right. Now.
You got it right, Mr. Gentleman.
Oh, okay. All right. Okay. Thank you. All right. Now, right here. Oops. Where is this at? Where I just put it? Oh yeah, right here. All right, so we going back to Evans versus Newton. All right, so right here we see the Pennsylvania. This is right here talking about private and public, and then we get a case law. Now it goes on. Let's see what else this judge has to say about public and private. He says a private golf. Now he's going to give you an example. This is an example. A private golf club, however, restricted to either Negro or white membership is one expression of freedom of association. So we're going to get a lot of people going to get upset because we got some golf clubs out there that will only allow white people in, even though the black people won't put together their own golf club and fund it themselves and build us a nice place where we can go play golf. We want to get mad at the white people and everything because they got together and built them a nice little golf club. And they don't want to have anybody in, but it's private. They can do that if they want to. That is not a violation of the law. That is an expression of a person's preferences, and everybody has a right to his or her preferences as long as it is kept private. If it doesn't come in, they can't bring it in the public. So right here, he's giving an example. Now, what's the next one? But a municipal golf course that serves only one race is state activity indicating a preference on a matter to which the state must be neutral. Okay, there are two words in this sentence that let you know that it is public. What are those two words? Can somebody answer for me?
Municipal and state.
That's exactly correct. Who was that? Who was that?
Oh, you said, who said, oh, Dretta.
Oh, Dretta. Okay, I just wanted your name. That was excellent. You're 100% right. Now, is this making sense to you, Dretta, as I'm reading this?
Actually, yes, because Yusuf, does that even apply like when they hire as well? They can hire whomever they want when it's a private club?
They sure can. When it's private, they can do whatever they want to do. The state cannot intervene in private matters. The state can only intervene in public matters. That's why I'm doing this for y'all, because y'all need to know this. The Constitution is public. Let me show you this right here. Somebody want to read this for me? Somebody read this for me. Anybody?
All right. Public law.
That's right. Public law.
Public law is that part of law which governs relationships between individuals and the government, and those relationships between individuals which are of direct concern to the society. Public law compromises constitutional law, administrative law, tax law, and criminal law.
Okay, wait, stop. Public law comprises constitutional law, administrative law, tax law, and criminal law, as well as procedural law. In public law, mandatory rules prevail. Laws concerning relationship between individuals belong to private law. Okay? Now, that says it all. Public law comprises what? Constitutional law, administrative law, tax law, and criminal law. Now, when you look on my chart that I have constitutional law, criminal law, administrative law. This part should be public international law, and tax law should be included on here also. So if you're private, tax law is on what side of the fence? The public. So if you're on the private side, can you be taxed?
No.
All right. So no private property cannot be taxed. That's why there is a clause in the Constitution that says private property can only be taken with due process of law and just compensation. It doesn't say they can't take your private property. It just says that they have to compensate you for it, and they have to have a good reason for it. There has to be what's called a compelling public interest test. That's what they use to determine whether or not they can take private property. But I want people to understand this, that the good of the many outweighs the good of the few. That is the principle behind them taking private property if need be. Okay? But I want everybody to understand that constitutional law is on the public side. Now, if you're over here floating in the public, you do have what is called constitutional rights. But if you're over here on the private, you have what are called constitutionally protected rights, because the Constitution is a restraint on government that keeps them from hopping this fence right here and coming over into the private. Does that make sense to everyone, or is anyone confused on what I just said? Let me give you something else to pound this home. Y'all too quiet. I don't like it when y'all get quiet. Y'all better open up them damn mics when I ask a question, or it's gonna be a long night. All right, right here. There's a document called Paper Arrows. This is a good document for the newbie too. Paper Arrows. Very, very good document for a newbie to read. If you're a beginner in all of this, this is a good book for you to read. It's called Paper Arrows. Got some real good definitions in here. But it talks about a case, and it gets real interesting. Where it talks about his misconceptions. Y'all need to read this. This is real good. But right here, talks about the Republic. Do you have constitutional right to work? Their laws don't apply to you. Self-government, citizens of corporations, fraud everywhere, separation of powers, strict to come in. All right, Barron versus Baltimore. The Constitution is fraud, is what he believes. I've said it before many times that the Constitution of the United States is one of the biggest frauds ever perpetrated on the face of the earth. Indeed, it was. The concept that we believe that it applies to us and gives us rights is also a fraud, and he's absolutely correct. I've upset a lot of people with that statement, and one man got so upset that he began to search to prove me wrong. I made him so mad that it caused him to get up and go work to find out how he got where he was on his own instead of just listening to me. And he found a court case while he was attempting to prove me wrong. The case was Barron versus Baltimore. Mr. Barron sued the city of Baltimore because they did some excavation work on some land right behind his building, which was located on the waterfront. He had a marine business where he brought in ships and unloaded them. The city of Baltimore's excavation work silted the harbor to the point where ships could not go in and out of his wharf. He filed a claim against the city and stated that the city had effectively taken his property without giving him compensation for it. He claimed that violated the Fifth Amendment to the U.S. Constitution. Here is what the judge had to say about the Fifth Amendment to the United States Constitution and the Constitution itself. And this is the judge. Listen closely. The provisions of the Fifth Amendment to the Constitution of the United States declaring that private property should not be taken for public use except for just compensation is intended solely as a limitation on the exercise of the power by the government of the United States. Why would they refer to the first 10 amendments as the Bill of Rights? The judge just said that the Fifth Amendment was a limit of power. Why not call it the Bill of Limitations? The only answer that comes to mind is that the government must be the one with the rights, which it is. It has those rights all the way up to the limitations spelled out in the first 10 amendments. The Bill of Rights is only for the people in government, and that's what public is. Public is government. The Constitution does not give y'all rights. Every Moor that is teaching that, every person out there on YouTube teaching that does not understand law. Well, this thing can be broken down so very simply to demonstrate the biggest fraud being perpetrated against people is this thing called constitutional rights. That's a fraud. Let's see what else this judge said. The judge went on to say it is not applicable to the legislation of the states, but the 14th Amendment altered that statement later on. That's right, because the Constitution at first didn't have anything to do with the several states. That's why they have their own individual constitutions. However, once that 14th Amendment was brought in, that made another class of citizenship that made people a citizen of the federal government and a citizen of their individual states. Now, the 14th Amendment in 1868 supposedly extended the Bill of Rights to the states. I'm going to show you that it still had nothing to do with me and you. If it was intended solely as a limitation on the exercise of the power of the government of the United States, then the Bill of Rights and the Constitution were intended for the United States only. They were not intended for the people of America who were not citizens and not resident within the government. It did not apply to them. The judge continued. Listen else what this judge said. The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. Oh man, does anybody not see that or not understand what this judge just said? See, another thing that people get confused on is on this word United States. They think United States is talking about the several states or all 50 states coming together. That's not what it's referencing. So right here, he's talking about the government. That pretty much limits it. It goes right back to what I told you, this other definition in Corpus Juris said about it being self-regulating. It only had internal power to make laws and regulations for itself. The government has the power to regulate itself and only itself. It does not have the power to regulate the people in the states. The government has internal power only until a business deal is done, is established, and a contract is signed. He goes on to explain further. Each state established a constitution for itself, and in each constitution is provided such limitations and restrictions on its powers as its particular government's judgment dictated. The people of the United States form such a government for the United States as they suppose best adapted to their situation and best calculated to promote their interests. That fits the corporate understanding very well. Their interests were to go into business and make a profit. They established a corporation and called it United States. All right, and I ain't gonna go any further, but you can read this. It's a very good read. Now, when we go back to Evans versus Newton, Now we begin to understand when we see this word municipal, we're talking about government. When we see the word state, we're talking about government. Okay? So this is the private sentence right here. A private golf club, however restricted to either Negro or white membership, is one expression of freedom of association. But a municipal public golf course that serves only one race is state public activity, indicating a preference on a matter as to which the state public must be neutral. Now, did you notice that they had state with a capital S and state with a small s? That was real interesting. I'll get into that later. What is private action and what is state action is not always easy to determine. So in this sentence right here, you see what is private action and what is state public action is not always easy to determine. See Burton versus Wilmington. Now we're going to talk about conduct. What do you judge? What is the minimum contact? Minimum contact is solely based off of your conduct. Do they care about what's on your paperwork? No, because they have something called substance versus form. The form will be your paperwork. The substance will be your conduct. Conduct actions speak louder than words. So conduct that is formally private may become so entwined with governmental policies or so impregnated with governmental character as to become subject to what? Public limitations or constitutional limitations placed upon state action. All right, so you may be private, but if you start engaging in conduct that was private and then you start coming over into the public, then they're going to bring the Constitution out on you, and now you're going to fall up under their jurisdiction. Is anybody confused on what this means right here?
No.
Okay, let's keep going. All right. Now, it says the action of a city in serving as trustee of property under a private will, serving the segregated cause is an obvious example. See Pennsylvania versus Board of Trust. Notice that every time this judge says something, he always does a case citation because these case citations are what is called controlling the judge. Controlling the judge. Let me show you something. Let me show y'all something. Make sure I got all these people in here too. Oops. Got some people who are trying to get in. Hold on, y'all. Just give me a second. I'm trying to get in too. All right. So let's see. Pull this up for you. Okay. This was an interesting article that is sent out by something called Jurisdictionary. Anybody ever heard of Jurisdictionary? I have a copy of Jurisdictionary. I'll see if I can find it. I'll put it in the folder for y'all. But you definitely is a good thing to get on their mailing list. And they sent out an email that says how to control the judge. Can you win without controlling the judge? You cannot. Control the judge or lose. There's no other way. Laws, rule, testimony, and evidence count for nothing if you can't control the judge. You must control the judge. This is your number one job if you want to win. threaten appeal, repeat internet legal mythology, demand to see his oath of office, challenges jurisdiction based on the color of the fringe of the courtroom flag, and you'll get absolutely nowhere. Cite appellate court opinions that agree with you and what you want, and threaten appeal if the judge doesn't agree with those appellate court opinions. It's stupid to march into court demanding one's constitutional rights, expecting the judge to admit your evidence, deny evidence, and tricks presented by your opponent and award judgment in your favor. It just doesn't work that way. Know how to show the judge you will win on appeal if the judge rules against you. All right? Now, how you do that is through case law. And I used to talk about that more on there, but how you control a judge is through case law. Now, when you see these judges talking, every time they get through saying something, they always cite a case because they have to show support for the statement that they just made. You have to remember that these judges are administrators. All right, so they are being controlled by stare decisis or prior case law. Everything that they say has to have some sort of legal foundation. All right, now, this is why case law is important for you to study, because this is how you control the judge. You cannot control the judge without understanding case law. Stare decisis means a thing already decided. So what you're doing is you're showing the judge, when you bring up a point of law, you're showing him that this thing has already been determined before. And here's where you can go to find it. So every time this judge says something, he's giving you a case that supports his determination. So when he says what is private action and what is state action is not always easy to determine, then he gives you some case law to support it. Conduct that is formally private may become so intertwined with governmental policies or so impregnated with a governmental character as to become subject to the constitutional limitations placed upon state action. The action of a city in serving as trustee of property under a private will, serving the segregated cause is an obvious example. See Pennsylvania versus Board of Trust. A town may be privately owned and managed. What did the judge just tell you? What did the judge just enlighten you about something that is going on in America? That towns may be what?
Private.
Privately owned
So there's some
and
towns.
managed.
There are some towns out here in the United States of America that are private and managed privately. They under a trust. I want the Moors to take note of this. But that does not necessarily allow the company to treat it as if it were wholly in the private sector. You know why? Because as we're saying, this town, even though it is private, it has some conduct that will bring it into the public. And he's going to give you an example. Well, what conduct can a town engage in that will bring it into the public? Well, they tell you right here in the next sentence. Thus, we held in Marsh versus Alabama. Now, why did the judge say, thus we held? Because the judge, all these court citations are other examples of other determinations that the Supreme Court has already made. It's their very own decision. And they can't contradict something that they've already said. Like it is, nothing is new under the sun. Whatever problem that you have, trust me, somebody else has already had that problem. But in the few instances where no one has had your particular thing happen, does anybody know the legal word for that? Anybody want to tell me what the legal word for that is? When you got something totally new. Everybody give up? novel case is a case for which no precedent can be found. It is a peculiar or extraordinary case arising in the complex and diversified affairs of men, which cannot be classified under any of the distinct heads under which jurisdiction has theretofore been administered. A novel case is one not found in all of the books. All right? So you need to write that word down and add it into your vocabulary, because I'm going to be asking you what that means. So, so a novel case means that the judge would not be able to find something like that. But every time you see these judges put a citation, he's letting you know, look, we already had the same thing happen before. Here it is right here. And here's what we thought about that. Is anybody confused on that? I bet y'all didn't know I knew this much. Is there any attorneys on? I bet you they just like, oh, I can't believe it. Can't believe he knows all this. Any questions? I'm going to take a quick break, y'all, because my throat is hurting very, very bad. I'm going to go get some of this garlic real quick. Y'all take a 15-minute break and let this marinate for a while and do some some checking. Okay, but is all of this making sense so far? If this is not making sense, let me know. Where can you find case law? I'm going to tell you, Christian, right here. It's called Google Scholar. Google Scholar is giving Westlaw and all those places you pay money for a run for the money. I think they're trying to take them out. When you go to Google Scholar, you see articles, which are good to also, and case law. If you put in private trust, it's going to give you the articles, supplemental needs trust for, you got all the private and powerful family information. It'll give you all the destruction of trust. These are articles. But if we go back and you put in case law, then it'll give you all the case law. Pennsylvania versus Board of Directors of City Trust. That's one we were just talking about, I think. Evan versus Newton. United States versus Mitchell. All these about private trust. Look at all these cases. You can find them, a lot of them. There is no shortage of cases for you to read about private trust. So when an attorney tells you that common law trusts are not legal or whatever it is that they say, you got to tell him, look, man, you got to be the biggest damn fool on planet Earth, because I can pull not less than 100 cases right now off the internet and go and show you what the courts say about private trust. So shut the hell up. I don't want your damn legal living trust. You take that shit and stuff it up your ass. All right? That's what you tell them. Tell them. And Yusuf said it. He told me to tell you that. I got your back. Just tell him I said it. All right. I'm going to take a quick break. I'll be back in a little bit, okay? I got to take care of this throat. I don't know, my throat is hurting me. I've been talking. I've been screaming and you know, all that. So give me just a second. Okay, I'm back, everyone. Sorry about that. Yes, George, we're still on. I had to go get some medical attention. Anyway. Okay, everybody here? Okay, cool. All right, now I have another vocabulary word for you.
Yusuf, on the last vocabulary word, can you put it in the Dropbox? Because I couldn't write fast enough.
Well, the word novel,
Yeah, please.
I just put it in the chat for you.
Okay, thanks.
And then I want you to write down controlling case law. Controlling case law and stare decisis. The legal principle of determining points in litigation according to precedent. All right. So the precedent. So we're looking at precedent. An earlier event or action that is regarded as an example or guide to be considered in subsequent similar circumstances. So that's what controlling case law is. Stare decisis is court precedent. And if there is no precedent available, then we have what is called a novel situation, in which, once again, a novel case is a case where there's no precedent. So if there's no precedent can be found, it is considered novel. I'm going to put this in the chat. Y'all know the copies of everything in the chat also come with the webinars too. I'll put those in there for you too. Everything that gets put in these chats is recorded as well. And I forget sometimes, but I'll start including the chat in the webinar too. Y'all do know that, right?
Yes, sir.
Yeah, copies of the chat also are recorded and will be put into the webinar as well. Yes, your chat, everything in chat is recorded too. Okay, now back to Evans versus Newton. Now, so this right here is controlling case law. This is stare decisis. This is court precedent. This is how you control a judge. When you look at another book, let me give you one other thing. When you look at books like American Jurisprudence, like this right here on trust. Oh my God, it's gonna take too long to upload. Hold on, let me get another one. All right, you see right here, American Jurisprudence is nothing but a collection of court citation or legal precedent. Every time you read a sentence in American Jurisprudence, you're gonna see a number at the end of it. What that's letting you know is it's a citation of authority. That's where they're pulling it from. They do the same thing in American Jurisprudence. Everything that is stated in it is supported by case citation. No different than when you're reading right here with the judge. Does everybody see that? This is why I read, that's why I'm always talking about American Jurisprudence. This is why you should resort there first when you start your study on any particular subject. You should go to the legal encyclopedias first. Now, another note about citations, you cannot use citations just from anywhere. If you are on a state action, you can only use citations that are from your state. And if it's like if it's on a federal level, you want to use citations from the federal court from that district. Does that make sense? Don't come in my court talking about something that's going on in California. If I'm a federal judge, I don't give a damn about that. Show me what we have decided right here in our jurisdiction. That's another jurisdiction. Now that should be simple. Is there anyone who is confused on how to look at what court, the purpose of court citations or anything like that? So a town may be privately owned and managed, but that does not necessarily allow the company to treat it if it were wholly in the private sector. Thus, we held in Marsh versus Alabama that the exercise of constitutionally protected rights, oh, did this Supreme Court judge just say constitutionally protected rights? Did he just say that? Or was that something like that Yusuf El made up? I mean, thus that the exercise of constitutionally protected rights on the public streets of a company town could not be denied the owner. There are two separate books. That's my opinion on it. You got American Jurisprudence Forms and Pleadings books too. It's very good. I haven't read the one you're talking about, but there are a lot of good forms and pleadings books out there. But it says, a state is not justified, we said, in permitting a corporation to govern a community of citizens so as to restrict their fundamental liberties. We have also held that where a state delegates an aspect of the elected process to private groups, they become subject to the same restraints as the state. Now, this is important. What did this judge just say? Permitting a corporation to govern a community. Isn't this what we are fucking talking about every day? In the United States, a corporation governing a community of citizens, but they cannot do what? Restrict their fundamental liberties. What are fundamental liberties? What are those? Civil rights and liberties is not, yeah. We probably have to go in, we have to go in another, a separate class on that, because liberties are not rights. But let's get back. I'll go back to that. Okay. We also held that where state delegates an aspect of the elected process to private groups, they become subject to the same restraints as the state. That is to say, when private individuals or groups are endowed by the state with powers or functions governmental in nature, they become agencies or instrumentalities of the state and subject to its constitutional limitations. You cannot mix public and private. If you do, what happens? If you taint your private process with anything from the public, what happens? Public and private do not mix. Okay? You know, that's kind of just like I guess like a white and a black person. You know, white and black person have a baby, the baby's always black. You know, on why white people can stay white, you got to stay white with on the white side. You come and mix anywhere on the other side, yeah, you tainted it. That's the same thing with public and private, okay? You know, if the private comes anywhere in the public, it's always public. I think that's a good illustration. It's funny, but I think that's a pretty good illustration. All right. Let's keep going. Yet generalizations do not decide concrete cases, only by sifting facts and weighing circumstances. And then he gave a case citation. Can we determine whether the reach of the 14th Amendment extends to a particular case? The range of governmental activities is broad and varied, and the fact that government has engaged in a particular activity does not necessarily mean that an individual entrepreneur or manager of the same kind of undertaking suffers the same constitutional inhibition. While a state may not segregate public schools so as to exclude one or more religious groups, those sects may maintain their own parochial educational system. Oh my God. And here's the case. So if you're in the Moors or any religious group, what case should you be reading so you can get a thorough understanding that if you're going to make a private school, how to make a real private school? I'm not talking about these de facto private schools that people run around here calling private schools. But it has to be what? Religious. It's private. So you can make your, so what do you see? You see the Mormons, they have a private school. What is it? What is the name of their college? Brigham Young. They got one over there in Hawaii too. But the thing is that you see these religions establish their own private schools, and they can exclude whoever they want to because it's not public in character. But if it's receiving any public funds, it will fall under some sort of public limitations, meaning that they cannot segregate. That was the whole thing behind desegregation. It was a violation of the Constitution in public schools. Does everybody understand that? So yeah, so if you wanted to, yeah, exactly. So if you want to, and that also goes to show that a lot of people in Alabama and all them places, they were ignorant too, pulling out water hoses and all that kind of stuff on people. If they wanted to exclude another race of people from their institutions, they should have set up their own private schools. They could have done that with no problem whatsoever. All right. Now let's look. Now let's look at this. This is why they have so much police intervention. Any good resource on how to appropriately live privately. That's what we talk about every day on high frequency radio. I mean, you could go to. Yeah, I do got a good resource.
I mean, if you just right off the rip, you just want to start just reading, getting some information on privacy and all that, you could go right here to, I mean, I'm always talking about it, and it's a very good I think I passed it. Very good website to go to, and that is where is it at? Oops, must be down here. Yeah, Eden Press. Yeah, exactly. Eden Press. Go to Eden Press. Go over there right here, Eden Press. What does it say? Eden Press. Privacy catalog. This whole website is devoted to privacy. All right. Now, and as a matter of fact, we're gonna start going through some of these things on this website, because it got very inexpensive books. You got $5 books, things like that, writing successful how-to books, novels, getting rich selling real estate you don't own, money making with newsletters, why you should have a portable office. That's interesting. Auto sales, potted plants, flea market sales. You know, all this is showing you how to do what? How to move in the private side. I bet you that is interesting right there. 75 ways to cash in at home. I mean, this looks pretty interesting. Let's see, how to $1 million hobbies. Underground car dealer. Interesting. They got that one $30. That must got some good information in it. Ragnar's Guide to the Underground Economy. I bet you that's a good document too. I bet you that's good. The Underground Database, that may be interesting. Underground Businesses, how to become rich as a flea market promoter. Let's look at some other ones. How to earn $15 to $60 per hour pro detailing cars and trucks and vans. This right here is just Seminar Riches, the complete manual on running a high-profit seminar learning center. I need to read that. Brokering seminars, easy work, big money. I mean, look at all this stuff. All this is to teach you how to move. How to move. Hold on for a second, y'all. Somebody's cussing me out. Are they for real? Wow, people are listening to. Okay. Where was I at? Okay, are there any questions real quick? Okay. Let's get back to the case. If a testator, now what is a testator? A testator, if you're intestate, you died without a will. If you're a testate, you died with a will. So a testator is a person who leaves a will. So if a testator wanted to leave a school or center for the use of one race only, and in no way implicated the state in the supervision, control, management of that facility, we assume arguendo, and that means for argument's sake. That's what this word right here, arguendo, means. For argument's sake, that no constitutional difficulty would be encountered. So what did the judge just do right here? He told you how to have a private school. A private school means that state cannot what?
Regulate or tax it?
No, it says the state cannot supervise it, control it, or manage it. So if you want it to be private, the state or the public can have no supervision in it, no control over it, and no management. And you can't take any public funds. If you take some public funds, they're coming in to regulate it, supervise it, and control it. That's called public school, which 99% of the people in the United States attend. public school, which are, it should be called government-funded institutions. Why? Which is another reason why they do not teach you how to run your own business, because government-funded schools have a curriculum that serves the government, not you. Public and private do not mix. They don't ever mix them. You don't either. Exactly. They don't have nothing anywhere teaching you how to start your own business, because they teach people how to come work for them, not you, within their system. Yep, if you want to work outside the public, you got to learn that shit on your own. I can't even call it indoctrination. I mean, they're doing what they're supposed to do. The public supports the public. The public only needs 15% of the population to be educated. The other 85%, all they need to do is be mindless workers. That serves the public interest. They're doing what is necessary. Don't get mad, get even. All right, let's get back to, so right here we just see what this judge just told us, that if you wanted to have your private school, okay, what you need to do. The government needs to be totally excluded from that. Now it says this park, however, is of a different posture. Now you got to remember, this case is about a private trust that is being administered by public trustees. In other words, it was private, and then and then the senator, when he died, he put a will. It was called a testamentary trust, because his will got converted into a trust upon his death and the death of his spouse and children. Okay, it got conveyed into trust, and the city was appointed as trustees. But there was a conflict because the trustees were public, and the trust itself was private, and there were conditions in the trust that violated public policy. So the trustees had a duty that was a contradiction for them. They have a public duty to do, and then they also have a duty that the trustees telling them to do. They couldn't do both. You can't come into the public, and that's why they say you cannot draft a trust that violates public policy or one of the public policies. Because if that trust is brought into the public and it contains provisions in it that violate something in the public, that trust is going to be terminated. Does everybody understand that? So let's talk some more about the park, and let's see what this judge says. It says the park, however, is in a different posture. For years, it was an integral part of the city of Macon's activities. From the pleadings, we assume it was swept, manicured, watered, patrolled, and maintained by the city as a public facility for whites only, as well as granted tax exemption under Georgia Code annotated subsection 92-201. The momentum it acquired as a public facility is certainly not dissipated ipso facto by the appointment of private trustees. So far as this record shows, there has been no change in municipal maintenance and concern over this facility. Whether these public characteristics will in time be dissipated is wholly conjectural. If the municipality remains entwined in the management or control of the park, it remains subject to the restraints of the 14th Amendment, just as the Private Utility and Public Utilities Commission versus Polak remains subject to the 5th Amendment because of the surveillance which federal agencies had over its affairs. We only hold that where the tradition of municipal control have become firmly established, we cannot take judicial notice that the mere substitution of trustees instantly transferred this park from the public to the private sector. Anybody want to break that down for me right now while I sip on this tea? Somebody break this down for me. And we'll start by looking up this word right here, ipso facto. Got to get your vocabulary. The enemy of one's enemy may be ipso facto a friend. It's a Latin phrase directly determined by the fact itself. Right. Okay. Write that down. Write that down on your cards, because whenever you see that word again, you're supposed to know what it means. So we go back. The momentum it acquired as a public facility is certainly not dissipated by the fact of itself by the appointment of a private trustee. Anybody want to take an attempt of decoding this and putting this particular paragraph in the layman's terms? Who wants to take a stab at that? Explain that paragraph to me.
I'll try it, Yusef.
All right, go ahead.
All right. So to me, it simply means that based upon the function of the municipality governing this private park, their actions in the public made it so that they could not maintain having it as a private whites-only facility. They're invested. Everything they did with the maintenance, the care, and all of that, all of their activity pointed to them managing that and making it public. Therefore, they had to be a part of the public responsibilities or governance, if you will, in reference to the Constitution.
Okay, now that's partially correct, and that is the reason why we do these webinars, so I can explain this to you. Okay, there is a term in here, and it's right here: the momentum it acquired as a public facility. This is going to be the key point that the other justices are going to attack in their opinions. What this judge is saying is, yeah, you're going to appoint private trustees to it, but just because you appoint private trustees doesn't automatically make it completely private, because look at all the momentum it acquired by all the public stuff that was given to it. So it's been so tainted by the public so much that even if you did appoint private trustees to it, we still do not consider it a completely private trust. Now, this is going to generate an argument, a firestorm. All the justices are not going to agree on this point, but I wanted to point that out to you. This is what this particular paragraph is talking about. This is why we do these classes, because you got to learn how to read case law, because case law is going to give you a significant amount of education as it relates to trust. This is where you get your authority from on a certain matter, because if all roads lead to court, you need to already know what decisions have already been made in courts on certain circumstances. This is why you read case law. This is why attorneys read case law. When attorneys prepare for a case, that's what you see them at the law library doing, looking up case law. This is what they do, what we're doing right now. They're trying to find controlling case law to control the judge. All right, so let's keep going. But that was a very good attempt. Thank you for that. I mean, you were partially correct. Now, the conclusion is buttressed by the nature of the service rendered the community by a park. The service rendered even by a private park of this character is municipal in nature. It is open to every white person, there being no selective element other than race. Golf clubs, social centers, luncheon clubs, schools, such as Tuskegee, was at least in origin, and other like organizations in the private sector are awfully racially oriented. A park, on the other hand, is more like a fire department or police department that traditionally serves the community. Mass recreation through the use of parks is plainly in the public domain, and state courts that aid private parties to perform that public function on a segregated basis implicate the state in conduct prescribed by the 14th Amendment. Like the streets of the company town in Marsh versus Alabama, the elected process of Terry versus Adams, and the transit system of public utilities versus Polack, the predominant character and purpose of this park are municipal. Under the circumstances of this case, we cannot but conclude that the public character of this park requires that it be treated as a public institution subject to the command of the 14th Amendment, regardless of how now has title under state law. We may fairly assume that had the Georgia courts been of the view that even in private hands, the park may not be operated for the public on a segregated basis, the resignation would not have been approved and private trustees appointed. We put the matter that way because on the record, we cannot say that the transfer of title per se disentangled the park from segregation under the municipal regime that long controlled it. Since the judgment below gives effect to that purpose, it must be and is reversed. So this judge reversed the decision of the Georgia courts because the Georgia courts affirmed everything all the way up to the Supreme Court. That family won. But when it got to the Supreme Court, they reversed it and said, well, just because you appointed a private trustee didn't make it all the way private. Look at all the advantages that y'all have taken from the public. This park has been tainted with so much public influence that just changing it to a private trustee is not going to make it private. Now, they all do not agree on that. And this is an interesting thing about this particular case because the name of the judges is what I found interesting. You have a justice named Justice White and you have a justice named Justice Black. White and black. And so, yeah, Justice Black, he went first. And now we're going to talk about
Muted. Unmuted.
Okay, I'm back. Something happened to my link real quick. I apologize. I'm back. Y'all hear me? Okay. So we have two justices, Justice White and Justice Black. I thought that was interesting. So Justice Black went first. Now we're going to hear Justice White, what he has to say. I thought that was interesting too. I mean, you got this segregation case and then you got Justice White, Justice Black. Wow. Anyway, I don't know. No, I don't know. As Mr. Justice Black emphasizes, this case comes to us in the very narrow. Now, that was the first judge. Now, what you do is you got, the Supreme Court got like what, about 9 justices. So there were like, I think 3 judges that made the decision on this. All right. So what it does is what we read first was Justice Black's opinion. Now, we're going to read what Mr. Justice White has to say. You get to read what each of the individual Supreme Court justices think about the case. So next, we're going to read what Mr. Justice White has to say about this and what his decision is. He says, as Mr. Justice Black emphasizes, this case comes to us in the very narrow context of a state court judgment accepting the resignation of a trustee and appointing successor trustees, which is what the courts do in situations like this. That is equitable, and that's what courts do. It wasn't anything wrong with that. The lower court judgment does not enjoin the new trustees to comply with the racial restriction in the trust, and there is therefore no presented for decision the question whether, should the trustees fail to exclude Negroes from the park, state judicial enforcement of the racial restriction would constitute discriminatory state action forbidden by the Equal Protection Clause of the 14th Amendment. But we do not have properly before us, in my opinion, the question of whether the 14th Amendment prohibits the new trustees from voluntarily excluding Negroes. This is so because decision of the state law question in this case was not independent of that federal question. The city's resignation, its acceptance by the state courts, and the appointment of new trustees were all based on the premise that the city could not, but private trustees could, obey the racial restriction in the trust without violating the federal constitution. If that premise was incorrect, this court should vacate the judgment below and remand for further consideration of the state law issues free from the compulsion of an erroneous view of federal law. Okay, that the 14th Amendment prohibits operation of the park on a segregated basis so long as the city as trustee is of course not disputed. See cases cited by the majority, other cases. Whether the successor trustees may themselves operate the park on a segregated basis is the question. The majority holds that they may not. I agree, but for different reasons. Okay, now the majority said that they may not, but they gave their reasons why, because they said that the park had been tainted with so much of a public character. Pay attention to what these people say. Now he got his own reason of why that even though they appointed private trustees, that the trust can no longer have a private character. And he's going to explain why. Y'all interested in hearing his reason? So right here,
Yeah.
it says, to a large extent, the majority grounds its conclusion that exclusion of Negroes from the park after the change in trustees would be state action and thus violative of the 14th Amendment on the existence of prior municipal involvement in the operation of the park. So the judge is saying, yeah, because of that prior municipal involvement, that, you know, it would be violated. And then he quotes what the judge says, what I pointed out earlier. The momentum the park acquired as a public facility is certainly not dissipated ipso facto by the appointment of private trustees. So far as this record shows, there has been no change in municipal maintenance and concern over this facility. Whether this public characteristics will in time be dissipated is wholly conjectural. We only hold that where the tradition of municipal control had become firmly established, we cannot take judicial notice that the mere substitution of trustees instantly transferred this park from the public to the private sector. So they won't take judicial notice of this fact because this park has been tainted with so much of a public character. Okay, now he's only quoting what Justice Black said. That's what Justice White is saying. So now he's going to say, it is equally evident that the record does not show continued involvement of the city in the operation of the park. The record is silent on this point. So the judge is pointing out, okay, ain't nothing in the case to show that the city is still involved. So this is conjectural. So what he's saying, on the contrary, the city's interest would seem to lead it to cut all ties with the operation of the park. It must be as clear to the city as to this court that if the city remains entwined in the management or control of the park, it remains subject to the restraints of the 14th Amendment. In other words, it remains in the public. And should segregation in the park be barred, the residuary beneficiaries would undoubtedly press their claim that failure of the trust purpose expressed in the racial restriction results in reversion of the park property. Anybody want to break this down? I'm gonna give somebody a chance to read this and tell me what that means right there. What does that mean? Anybody want to take a stab at that?
If they, I'll take one real quick. If they desegregate the park, the beneficiaries would have to make a claim that the trustees aren't doing their job to get them removed?
No. Okay.
Can I try?
Yeah, go ahead.
That if the segregation is changed, the park would go back. The beneficiaries would say that the park should go back to private.
Okay.
Go back from the municipality.
That's very
to the
good.
private.
I'm going to put it in easy terms for you. Because what this judge just did, he gave a clue to the beneficiaries what they should do, and just in case they cannot enforce the trust, the terms of the trust. The terms of the trust state that black people cannot come to the park. So right here it says, and should the segregation in the park be barred, what that means is if this court makes a decision that they cannot do that they cannot have this park and exclude black people, okay, the residuary beneficiaries, those are the heirs, all right, would undoubtedly press their claim that failure of the trust purpose is the indenture agreement, expressed in the racial restriction, results in reversion of the park property. In other words, since the purpose of the trust cannot be fulfilled, which was to exclude black people, so if this court rules in their favor, then the beneficiaries are going to file a claim that the trust collapsed and that the corpus of the trust revert back to them. So they're going to take it out of trust, and that is what ended up happening. What ended up happening is that the heirs of this estate, the trust had to collapse because it couldn't work and everything. And you know, anytime a trust collapses, whatever in the trust is given to the beneficiaries. So this park was in the trust, and because it collapsed, the park was handed over to the beneficiaries because they could not enforce the terms of the trust, which were to segregate black people. Does that make sense?
Now, in them doing that, are they able to create another trust and then like reassign that park into a different trust?
Yes, they can. It's their property. It's private property. Yeah, it would be good to do what's.
Yeah, but they
It would be good
public
to. It would.
affairs.
I'm sorry.
I was saying that they can't. When they got public trustees, they had to carry out public affairs, and they couldn't employ the private. The indenture, where it stated a private action, then it needed to stay in the private.
It had to stay in the private.
Correct. So when it came in the public,
Yeah, they couldn't.
right.
See, there is a equal protection clause under the 14th Amendment because blacks are protected under the 14th Amendment from racial discrimination. So nobody in the public, everybody in the public has to take an oath to uphold the Constitution. So when you have a municipality, which everybody in a municipality have a public character, they take oaths to uphold the Constitution, they can't effectively become trustees of a private trust where in the terms of the indenture, there's something violative of the Constitution, something they just sworn to uphold. So what they attempted to do was change out the trustees from public to private trustees who did not owe any allegiance to the Constitution. But what the Supreme Court justices are saying is, well, that doesn't matter anyway, because y'all done had this trust operating like this for about 50-something years, and it's been tainted with the public. So it doesn't matter what you do to it, it's going to retain a public character. And they're going to rule in that favor. And when they do, then the beneficiaries are going to press a claim. And it's almost like the Supreme, because right here, this Supreme Court justice just told these people what to do. He told them what to do. He said the residuary beneficiaries would undoubtedly press their claim. He's telling them what to do right there. To collapse the trust and get your property back. If y'all learn how to read these cases, y'all will see what these judges be doing in these cases, giving people hints and all kind of stuff. Sherry, you had a question.
Oh, so in other words, the intestor, the guy that put the trust together, should never have made these public trustees part of his private trust. Is that the whole gist of this thing?
That is the whole gist of it, but it's also illustrating the differences between public and private and how they don't mix, and why you as a trustee, you need to understand jurisdiction. Right now, this is an in-depth discussion on jurisdiction, which rests primarily on public and private. Okay? The public is one jurisdiction, the private is another. You got to learn the differences, because if you're operating a private trust, you got to learn how to stay in the private. And if you come into the public, you need to understand that you're going to lose some of your private protections to the extent that you were involved in the public.
One more question. Do you actually believe that these guys or women didn't have a clue about that? I don't.
Well, first of all, this trust went back to like the early 1900s. So you gotta always frame things with the times.
Okay, I didn't know it went back that long. I see.
Yeah, this go back. I mean, this trust, when it was, it was he did this in 1911. He made this in 1911. So, in 1911, the attitude of the country as a whole was, hey, niggas don't have no rights. So this came.
It was pretty crappy. Go ahead.
It was, but see, in 1965, what did we have happen in 1965? That was the what era?
Same old, you know what?
Civil rights era. Civil rights, exactly. So there was a desegregation a lot of desegregation, a lot of that was happening during that time. And that's why you're seeing something like this, because who were the people who were intervening right here?
As they should have.
Exactly. So I want you, I'm just doing this. I'm not trying to make this a black and white issue, because you can take it, you got to understand the times and the mentality of the people during those times. But what I am trying to emphasize is that the principles involved still apply just as today as they did back then. Does everybody understand that?
Yes, and I think it's an excellent case, to be honest with you. And quite frankly, I think all these folks that had these private trusts for that many years knew it, but they still have the attitude that they seem to be better than others, unfortunately.
Yes, they are, and you got to understand, we have to understand too, a lot of these towns, like this judge just said, are privately owned. You know, I'm under the impression that these cities, some of these cities are, you know, when you look at the names of these counties, when you go and dig into the history of them, a lot of them are private trusts.
How do they mix that, though, Yusuf? How do they do that?
Well, hey, listen, the only people who really have a right to vote are landowners. And it is it is my contention that today in the United States, we are living under a feudal type system. It's just not called a feudal system. But there are other people who own this land and we just live on it. And that's why we pay property taxes, which is like, you know, we paying our landlord. No different than what was going on in England.
Exactly. Thank you.
Yusuf, what I'm getting from this is if there's a problem that you're having, instead of having a rally, intervene.
Well,
So
yeah,
it's sort of like be like a Thurgood Marshall and look to have a lawsuit.
okay, let me tell you, let me, I'm glad you brought that up. Let's talk about the Michael Brown situation. All right. Now, I'm not going to get out and fucking picket and protest. I'm smarter than that, okay? You know, we got to stop demonstrating to the world how ignorant we are as it relates to law. There's a reason why when they shoot down somebody that nothing happens to the police officers or anything like that. Because number one, you are in a municipality and it's privately owned. The police have no duty to protect. Okay, so somebody explain this. Justices rule police do not have a constitutional duty to protect someone. Why is that? If they are not under the Constitution, okay, then what are they under?
Public law.
Wait. The Constitution is public, so
Okay.
they're protecting the public.
Okay, so who in the county has a constitutional duty? The police or the sheriff?
Sheriff.
The sheriff.
Okay, so now what is the difference between the police and the sheriff?
The sheriff swears to uphold the Constitution.
Were there any police officers in the Wild West?
No.
No,
Police protect property.
there were
Police
sheriffs.
Did anybody see the men who built America?
There were deputies.
Yeah.
Okay,
I see.
what happened when they took Rockefeller's, I think, was it Carnegie? No, it was Carnegie. When they took Carnegie's steel mill, okay, because, you know, they were just,
They brought in those mercenaries.
and they were
Yeah.
private what?
Private,
Yeah, mercenaries, like you said.
mercenaries, yeah.
And they shot and killed people. Did anything happen to them?
Nah,
No.
Why?
it was private.
Okay, when you're in the Wild West, if you and a man wanted to get into a fight and wanted to duel in the middle of the street, the sheriff would come and do what?
Officiated.
Why is that? Because it was a what?
It was a private affair.
Damn right. So as long as you didn't shoot the man in the back, if y'all want to shoot each other dead in the street, that's y'all business. They used to have, who was that, Burr? And who's the guy, Aaron Burr, had the duel with,
Hamilton? No.
yeah, is it Hamilton? I think it was Hamilton, Alexander Hamilton. And Burr killed Hamilton. Alexander Hamilton was the person who created the first central bank here in the United States of America. He was the first Secretary of Treasury. And him and Aaron Burr, it was Aaron Burr, Burr slays Hamilton in a duel. All right. Did Burr go to jail? Did he go to jail?
Guess not.
Why is that? Because I think Hamilton, look at this. It said, in a duel held in Weehawken, New Jersey, Vice President Aaron Burr fatally shoots his long political antagonist, Alexander Hamilton. Hamilton, a leading Federalist and the chief architect of America's political economy, died the following day. Alexander Hamilton, born of the, okay, I mean, Hamilton came to detest Burr, whom he regarded as a dangerous opportunist, and he often spoke ill of him. You know, he used to get into it, so he challenged him to a duel.
If the one I choose doesn't work, they'll help me find one that does.
All right, it was a private battle. The police, that's why I wanted y'all to watch that. The men who built the police, that's kind of like what they are. They're kind of like some sort of private mercenary group. You coming into these municipalities, they like privately owned. You need to study. You need to go to a American jurisprudence.
They wasn't just the average though. They wasn't just the average cats, man. The way that they reported them boys had more ammo and power than the U.S. military at the time.
They sure did. But the thing, my point is, they were under contract, which means they were private. Now you have what's called quasi-private municipality. Look at this, quasi-contractual obligations of municipalities. Let's see. We can, you really need to read an American jurisprudence. And I'm gonna tell you what's going on. All right. These cities have a public character and a private character. They're public when they're operating under their delegation of authority coming from the state, which gets its authority from the Constitution. They're private when they start operating for profit. You need to start understanding this. So a lot of times what they're not explaining when these people get shot down is when you go into these municipalities, you're going into a merchant district. What used to happen in old times when you would come into a city? You come into a city, the cities used to have walls. They would check your ass at the door. When you come into the city, you are under municipal law. Okay, when you read let me show y'all this real quick. I don't know if I can find it in here, but I can find it right here. Slavery defined. This came out of a law book. It's also in Priggs versus Pennsylvania, as well as in Dred Scott. Dred Scott, and not, I never hear anybody say this, but after I said this over the air, a lot of Moors came and sent me emails, say, damn, man, it's right there in the case in Dred Scott. By the general laws of nations, no nation is bound to recognize the state of slavery as the foreign slaves within its territorial dominions, when it is opposed to its own policy and institutions in favor of the subjects of other nations where slavery is recognized. If it does, it is a matter of comity. Comity means just consideration or goodwill, and not a matter of international right. Now, this last sentence is the sentence you got to pay attention to, because you find this sentence also in Dred Scott. The state of slavery is deemed, when they want to create a fiction, to be a mere municipal regulation. So what is slavery? It's a what? It's a synonym for municipal regulation. The only place that slavery exists is under municipal regulation. And are y'all starting to, are lights starting to come on?
Big time.
That's why you shouldn't even be pulled over, because the problem is that we don't know the definitions of words. And we think we are driving and we're a resident instead of a consumer.
Revelations 18:14. Then I heard another voice from heaven say, "Come out of her, my people, so that you will not share in her sins." Or like it says in King James. And I heard another voice from heaven saying, "Come out of her, my people, that ye be not partakers of her sins, and that you receive not her plagues." It's these cities I'm trying to tell you. These cities are a new occurrence. Carnegie is the reason that we have these cities, because he was the steel magnate and he was responsible for the building of these big cities. When they started building these cities, people started migrating from these country towns and places where they had basically their own, they could regulate their own activities, and they came into these centers where now they are under a regulative authority. They're being regulated. You got to study this, man. I'm not claiming to know everything about it, but you got to study the law and understand. I don't just jump out there when somebody gets shot down dead in the street, or like when that police officer body slammed that that young lady in the public school. Other people were outraged, and I'm not condoning any of the activities of these people. But what I am stating is we got to start understanding where we're at and stop just assuming that we have just plenary rights to do any and everything that we want, and we have constitutional rights and all of this madness, because we are not understanding truly the definition of freedom, jurisdiction, or any of these things. This is an excellent case that demonstrates public and private. Would you agree?
Yes.
I'm gonna take another. Go ahead. I'm gonna take another short break. When I come back, we're gonna continue. I gotta still work on my throat. You say, especially when I read it, Dion. Does it make more better? Are y'all able to better follow along when I read it? Does it make it more interesting and engaging?
Yeah, because you break it down. I mean, it's hard to read.
But what I want to know is, when you go back and read it, after I've given you the explanation, does it make more sense to you? Is it easier for you to read?
It is.
Yes.
Okay. Now and just don't say that to appease me, because that's why I'm doing this. I understand that this stuff can be hard to understand and comprehend. I'm trying to make it easy for you, show you what the words are, all these different things, what the judges are really saying, and then so you can grow in your understanding of reading case law. Because what you're going to do is, it's going to put you head and shoulders above the gurus, because none of the gurus read case law. Almost none of them. None of them do, because they don't understand it. Because it's not easy to read. It requires a lot of time, but this is where you're going to find the bulk of your information in reading case law. So let's take a 15-minute break, and I'm going to come back. I know I'm taking breaks, but y'all just bear with me tonight, okay? And I'll be back in 15 minutes. Okay, I'm back. Sorry about all the interruptions, y'all. Okay, y'all ready to continue? Everybody still here?
Yep.
Okay, y'all learning
Yeah, we're here.
anything? Let's do a recap right
Absolutely.
now. Can somebody give me, Dion, give me two things when I'm gonna do this. I see your mic's not open. Kristen, give me two things that you have learned tonight thus far that you didn't know before. Hello? I guess she's not there. Okay. Who is this? Jazzy? Oh, you're driving. Okay. Yeah, right. Okay. William, give me two things. Well, I'm gonna let somebody volunteer. I'll let somebody volunteer then. Somebody just volunteer. Who wants to come forward and tell me two things that they have learned that they didn't know before?
I'll check it out.
Okay, go ahead.
You can control the judge by using case law. Didn't know that. I've heard it before, testate and testor. You know what I'm saying? And now I'm clear on what that is.
Okay, great.
Yeah, I'll volunteer too. One of the things is that slavery is a municipal regulation, and that anybody that's interested in how to run a private school correctly should look at Pierce versus the Society of Sisters.
Great. All right. Anyone else want to add a remark? I'm going to give y'all this. Okay, let's see. I think this is it. Hold on. Anybody else? I guess nobody else learned anything, huh? Okay.
You know that's not true.
I know, I'm just.
That not.
I'll put in, you know, I mean, the two pieces, I mean, there's so much that I picked up tonight, but certainly the municipality piece and slavery was a new one. That was definitely something that I had not thought about or had known.
Okay.
And, you know, the other part was, you know, again, controlling the judge through the case law. Those are significant because, you know, in some instances we're challenged by some of these folks, and knowing who we're dealing with, and not only knowing who we're dealing with, but knowing how to hold them in check is what we're aspiring to learn. At least some of us, at least let me speak for myself. At least me, I'm trying to learn that while I'm in the process of getting this private situation and my affairs in order. And so those are two key pieces for me tonight, along with some other pieces. But that's, you asked for two.
Yeah, and you know what? That thing about controlling the judge is so important. The average person doesn't know this. They're just going to court willy-nilly or draft some pleading or something like that. They don't understand the importance of case citations. The first thing you do when you get involved in a case is go and look at somebody else who's already had the same problem that you did and how it ended for them. That's all you're doing. And then you show the judge, like, look, this has happened before. This is how y'all have already ruled, so y'all got to rule this same way again.
So now let me ask a quick question here, Yusef. Like, for example, with the affidavit process going in to situations on a private side, and you still having the public appearance in these cases, in these courts, you know, that's not a mixture of private and public?
Well, in public, you give notices. All right, so in the public only recognizes public. If you voluntarily participate in a public controversy, you become a public figure. You need to look up the definition of public figure in a law dictionary. Get an 8th edition or a 7th or 9th or 10th, and look up the word public figure. So the skill of going into court is learning how to maintain, or as the Moors say, stand on your square and not go into the public. But that's difficult to do because they have so many different, they use threat, duress, coercion, a lot of different methods to entice you into coming into their jurisdiction and taking on the liability of as trustee for that straw man. And that's what's going on. But no, in doing the affidavit, no, an affidavit is something that private people do. You know, you're declaring who you are. You know, let me read this for you too. This is Dred Scott. Slavery, being contrary to natural right, is created only by municipal law. First line. This is not only plain in itself and agreed by all writers on the subject, but is inferable from the Constitution and has been explicitly declared by this court. The Constitution refers to slaves as persons held to service in one state under the laws thereof. Nothing can be more clearly described a status created by municipal law. And in Friggs versus Pennsylvania, this court said, the state of slavery is deemed to be a municipal regulation founded on and limited to the range of territorial laws. The Supreme Court of Appeals of Kentucky said, slavery is sanctioned by the laws of this state, and the right to hold them under our municipal regulations is unquestionable. But we view this as a right existing by positive law of a municipal character without foundation in the law of nature or the unwritten common law. And it's against nature and the common law. They're telling you that it is. I mean, these people, man, you know, this, when you read some of their stuff, the only way, this is why they had to dehumanize black people. They had to say that you were not a man, that you're property. This is the Dred Scott case. This is a very, very good read right here. So let me see if I can copy this and put this in the chat. I mean, in your,
Just a little quick sidebar, you know, since Byrd slayed Hamilton, and Hamilton is responsible for the setup of the Federal Reserve or the central bank presence here in America, and they taken him off of that $20 bill and putting Harriet Tubman, who freed, you know what I'm saying, the slaves. I think that might be precluding something.
It may be. I haven't looked far enough into the matter to even comment on it, but I'll take note of that and I'll look into it and I'll give you my opinion on it.
Joe.
There, I just put this in the chat for you too, so y'all can read this. This is coming out of the Dred Scott case. All right. So a lot of people read this and they never even pay attention to that. And I've heard so many people talk about the Dred Scott. I said, did you read the Dred Scott case? What these people are saying? You understand what they're saying? So anyway. Let's get back to Evans versus Newton. All right, where were we at? We're on Mr. Justice Black, where he was quoting. Let's get down here. So we were just talking about how the judge is letting them know that they could press to get their property back, just in case the terms of the trust could not be enforced. He goes on, it seems unlikely that the city would act so as unnecessarily to jeopardize the continued existence of the centrally located park, which comprises about 100 acres and is one of the city's largest parks. That the city's own interest might lead it to extricate itself at once from operation of the park does not, of course, necessarily mean that it has done so. And I'm no more inclined than the majority to resolve this question by conjecture. I refer to possible inferences from the city's self-interest solely to emphasize that the record affords absolutely no basis for inferring continued involvement of the city in the management and control of the park. What the majority has done is to raise the presumption of one fact by showing the absence of proof of the converse. To postulate in this manner that the city's involvement has not been dissipated is simply a disguised form of conjecture and, I submit, is an insufficient basis for discretion for this case. I believe this judge is very, I'm so impressed with some of the way these judges think sometimes. And what this judge is saying is that the record doesn't reflect that the city is going to continue to administrate this trust. So you're operating off a presumption that it's going to continue to have some sort of involvement from some inference, because the record is absent declaring exactly the city's the lack of the city's continued involvement in it. So I love how this judge broke that down. This right here, this is called a soliloquy. I think that's what it's called. Syllogistic reasoning. This is legal reasoning. You need to understand how they reach conclusions on matters as well. They use syllogistic reasoning. Okay? The use and limits, like that, the use and limits of syllogistic reasoning in briefing cases. I like that. Let me see if I can say that. How many people knew that? That's something new for you to know too, isn't it?
That's part of the trivium logic.
Exactly. It's a science is what I'm trying to get to. Deductive and inductive reasoning based off of premises. It's a science. It's a scientific approach of reaching a conclusion. And when you understand how they reason and how they reach conclusion on things, it'll give you more of an appreciation for the intelligence of some of these justices as well. I enjoy reading case law because I get to really see, like this judge, Justice White right here. That was excellent. What he just said right there. This paragraph right here, this is beautiful, what he just did. He goes on, he said, I would nevertheless hold that the racial condition in the trust may not be given effect by the new trustees because, in my view, it is incurably tainted by discriminatory state legislation validating such a condition under state law. The state legislation to which I refer is subsection 69-504 and 69-505 of the Georgia Code, which were adopted in 1905, just 6 years before Senator Bacon's will was executed. Section 69504 and 69505 make lawful charitable trusts dedicated in perpetuity to the public use as a park, pleasure ground, or for other public purpose, and provide that the use of said park, pleasure ground, or other property so conveyed to said municipality may be limited to the white race only, or to white women and children only, or to the colored race only, or to colored women and children only, or to any other race, or to women and children of any race only. Notice how they used a little tricky language in here to make it not look like they were totally being biased, because they threw in there they could limit it to any race that they wanted it to. That was kind of tricky. Do you see what the Georgia did back then in 1905 in order to give the appearance that they were drafting legislation that was not going against the Constitution? That's why you got to really watch your legislatures too, because they always draft unconstitutional laws or legislative or statutes. Always. They do it all the time. They do it all the time. That's why it's the people's job to be vigilant and watch over them. But do you see that? That was a very good illustration of a crafty legislation that attempts to stay in the gray area between violating the Equal Protection Clause of the 14th Amendment and then trying to sneak in and allow, only one race of people to come in. That's what that senator kind of based that off of, that legislation that was right there. And then it goes on and says, as this legislation does not compel a trust settler to condition its grant upon use only by a racially designated class, the state cannot be said to have directly coerced private discrimination. Nevertheless, if the validity of the racial condition in Senator Bacon's trust would have been in doubt but for the 1905 statute, and if the statute removes such doubt only for racial restrictions, leaving the validity of non-racial restrictions still in question, the absence of coercive language in the legislation would not prevent application of the 14th Amendment. For such a statute would depart from a policy of strict neutrality in matters of private discrimination by enlisting the state's assistance only in the aid of racial discrimination, and would so involve the state in the private choice as to convert the infected private discrimination into state action subject to 14th Amendment. I mean, this guy is nice. And how he words this. He said, the word is so nice. For such statute would depart from a policy of strict neutrality. Okay, what is this right here? Strict neutrality in matters of private discrimination. The state is neutral on private discrimination. Do you see what these people are saying? You can be as discriminatory as you want to privately. They are neutral on matters of private discrimination because public and private do not what? Mix. I'm trying to get y'all to understand.
Hey, Yusuf.
Go ahead.
In that paragraph before you started reading that one, I'm looking at how he has in brackets may, meaning that must, in that sense, being that he has it bracketed.
You know what? And I'm glad that I did notice that too. But we have to read this sentence in context because I know you're talking about right here. It says, okay, this statute makes lawful charitable trust dedicated in perpetuity to the public use as a park, pleasure ground, or for other public purpose, and provide that use of said park, pleasure ground, or other property so conveyed to said municipality must be limited to the white race only, or to white women and children only, or to the colored race only, or to colored women and children only, or to any race, or to the women and children of any race only. The operative terms here are only. So yes, that could be construed to mean must. And they did bracket that because we all know that may has a different legal meaning than it normally does. And this is what this judge is getting into. He is attacking this statute because of the crafty language that is being utilized in it. And he's bringing it to the attention of the legislatures that they need to change.
So quick question, why are they leaving out men? Or am I missing something historically here?
Well, it says right here, the white race only. Or then you have your conjunction and then you include white women. You got to understand that, you know,
Okay.
women used to be considered men's property. I think it really still is. That's why they take on our last name. But I don't want to get in that conversation. That's why we had women's lib and all of this stuff, you know, in the feminist movement. But, you know, you got to understand, you got to take yourself back to the time. This was like the early, that legislation was drafted in 1905. How were people thinking in 1905?
I say, appreciate it.
How were women treated in 1905? Okay, everybody got that?
Yeah.
Okay. Although there are no Georgia decisions directly on the point and the question is therefore not free from doubt, the available authorities have led me to conclude that subsection 69504 and 69505 did involve the state in the private choice by favoring private racial discrimination over private discrimination based on grounds other than race. Apart from subsection 69504 and 505, the Georgia statute governing the determination of permissible objects of charitable trust is. This statute almost copies the statute of Elizabeth Newton versus Stark and has the effect of fully adopting in Georgia the common law of charities. We may therefore expect general charitable trust principles to be fully applicable in Georgia as elsewhere in the several states. Under such principles, there is grave doubt concerning whether a charitable trust for a part can be limited to the use of less than the whole public. So he's telling them right there, you got to allow the whole public in a public trust. You know, this judge is sending a message to these legislatures in Georgia right there. In the leading case of Commissioners for Special Purpose of Income Tax versus Pimsel, Lord McNaughton established the classification of charitable trusts that, with some modification, has since prevailed. And, you know, charitable trusts are the only ones that can exist in perpetuity as well. Charity, in its legal sense, comprises four principal divisions: trust for relief of poverty, trust for the advancement of education, and trust for the advancement of religion, and trust for other purposes beneficial to the community, not falling under any of the preceding heads. See also restatement second trust, which is the authority of trust that people are always referring to. A more general test of what is charitable is whether the accomplishment of the trust purpose is of such social interest to the community as to justify permitting property to be devoted to the purpose in perpetuity. The first three categories identified by Lord McNaughton designate trust purposes that have long been recognized as beneficial to the community as a whole, whether or not immediate benefit is restricted to a relatively small group, and that therefore satisfy the general test stated by Professor Scott, see restatement second trust. But the present trust falls under the fourth category and can therefore be sustained as charitable only because the generality of user beneficiaries establishes that it is beneficial to the community. Otherwise, a trust to establish a country club for the use of the residents of the wealthiest part of town will be charitable. Professor Scott states his principle as follows. As we have seen, a trust to promote the happiness or well-being of members of the community is charitable, although it is not a trust to relieve property, advance education, promote religion, or protect health. In such a case, however, the trust must be for the benefit of the members of the community generally, and not merely for the benefit of a class of persons. And I just got through reading Scott's on trust. I was just in the law library yesterday at Emory University, and I found Scott's on trust, which is very good, very good. If you go in the law library and you get this edition, something is real good to read is Scott's on trust. I think you'll enjoy that. Okay, accord. Trust for the town common was charitable. It is okay. And what he's doing right now, he's bringing up all of this to identify what a charitable trust is, and he's contrasting that with the trust that is under question right now to make a determination of just how far this trust has been tainted and how many public characteristics that it retains in its use. All right, and this is what this judge is weighing right now. Because once again, we're talking about public and private. Okay? A court, okay. Let me stop right here. Let me and he dissented right here. This case must be accordingly be viewed as one where the state has forbidden all private discrimination except racial discrimination. As a result, the state, through its regulations, has become involved to such a significant extent in bringing about the discriminatory provision in Senator Bacon's trust that the racial restriction must be held to reflect state policy and therefore to violate the 14th Amendment. For the reasons stated, I would vacate the judgment of the Georgia court and remand the case for further proceedings. All right. And that was Justice White, I think, who, and I think what he did was he did what? I think he also affirmed. He reversed it, Justice White. And then we have Justice, that was Justice White. This is Justice Black down here. He dissented. He said, I find nothing in the, and now he has a difference of opinion. He says, I find nothing in the United States Constitution that compels any city or state subdivision to hold title to property it does not want or to act as a trustee under a will when it chooses not to do so. And I supposed until now that the narrow question of whether a city could resign such a trusteeship or whether a state court could appoint successor trustees depended entirely on state law. Here, however, the court assumes that federal power exists to reverse the Supreme Court of Georgia for affirming a Georgia trial court's decree, which, as the Supreme Court held, did only these two things: accepted the resignation of the city of Macon as trustee of the Beaconsfield and appointed new trustees. And I'm going to say this judge is absolutely right, because I'm going to tell you what these other two judges were doing. These other two judges are doing, they're trying to eliminate discrimination. But they really didn't have a sound basis for, in my opinion, of reversing the Supreme Court of Georgia's decision. But they did it anyway, for in the interest, because this is equity we're talking about, in the interest of promoting the welfare of the country as a whole and the elimination of discrimination and so forth. That's why you see the way some of these decisions have went, even though the logic behind it was kind of tenuous, as it was my opinion, because this judge right here, he brings it up. That look, all they did was accept the resignation and appoint new trustees, which was they were supposed to do. What you talking about? Y'all going off of, well, what if the city still is involved in it and all of this? All that is complete conjecture. We have no facts in the case that would, substantiate any type of presumption of that nature. Wouldn't y'all agree?
Yes, agreed.
Okay, let's keep going. The state Supreme Court's interpretation of the scope and effect of this Georgia decree should be binding upon us unless the state Supreme Court has somehow lost its power to control and limit the scope and effect of Georgia trial court decrees relating to Georgia wills, creating Georgia trusts of Georgia property. A holding that ignores this state power would be so destructive of our state judicial system that it could find no support, I think, in our federal constitution or in any of this court's prior decisions. For myself, I therefore accept the decision of the Georgia Supreme Court as holding only what it declared it held, namely that the trial court committed no error under Georgia law in accepting the city of Macon's resignation as trustee and in appointing successor trustees to execute the Bacon Trust. I'm not sure that this court is passing at all on the only two questions the Georgia Supreme Court decided in approving the city's resignation as trustee and the appointment of successors. If the court is holding that a state is without these powers, it is certainly a drastic departure from settled constitutional doctrine and a vastly important one, which I cannot refrain from saying deserves a clearer explanation than is given. Ambiguity cannot, however, conceal the revolutionary nature of such a holding. If this is the court's holding, nor successfully obscure and tremendous lopping off of power heretofore uniformly conceded by all to belong to the states. The ambiguous and confusing disposition of such highly important questions is particularly disturbing to me
because the court's discussion of the constitutional status of the park comes in the nature of an advisory opinion on federal constitutional questions the Georgia Supreme Court did not decide. Consequently, for all the foregoing reasons, and particularly since the Georgia courts decided no federal constitutional question, I agree with my brother Harlan that the writ of certiorari should have been dismissed and been privately granted. Wow. Questions are, I mean, this is beautiful what he's saying too. I mean, I'm looking at the dissenting opinion, and this judge, he's on point. He's like, man, he's like, what are y'all talking about? All this stuff, they didn't do anything wrong. The questions of this court's jurisdiction would be different, of course, if either the mere resignation or appointment of trustees under a will was prohibited by some federal constitutional provision. But there is none. The court implies, however, that the city's resignation and the state court's appointment of new trustees amounted to state-sponsored racial inequality, which, of course, if correct, would present a federal constitutional question. This suggestion rests on a further implication by the court that the Georgia court's decree would result in the operation of Bacon Fields Park on a racially segregated basis. This record here, for several reasons, can support no implications. One, the state Supreme Court specifically limited the effect of the decree it affirmed to approval of the city's resignation as trustee and the appointment of new ones. And two, the new trustees were not directed to operate the park on a discriminatory basis. And three, there is no indication that they have done so. Well, I don't agree with the judge there, because even though the trustees are directed to operate the park on a discriminatory basis, the what is telling them to do that? The indenture.
Actually, how the trust is set up.
Yeah, how the trust is set up, the indenture agreement. So I don't agree with him right there. All right, and we know from reading cases that that your trust can be construed in the same way just by the verbiage that's in the indenture agreement. So it can be properly assumed that a power granted to a trustee, even though that trustee doesn't exercise the power, still is going to be taken in consideration. So that trust document gives those trustees the power to discriminate. Whether those trustees execute on those powers or not is irrelevant. Does everybody understand that?
Yes.
Yes.
Okay, this is the last opinion I'm going to read, but I think y'all are getting the point about this. Are y'all starting to kind of, your mind starting to unfold about this public and private? That was the point of doing this tonight, because this case teeters almost entirely on questions of public and private. You're getting introduced to different language. You know, they may not say public, they may say constitution, they may say municipal, they may say state, but all of those words mean public. Okay? There's only two things, public law and private law, and they do not mix. Wait a minute, George, what is it that you don't understand, George? What's the problem? Why is it so advanced? Is this your first webinar that you've attended?
Yes, sir.
Okay, so you're new to all this information. Is that when
Yes.
Okay. Well,
yes, sir. This is all new to me, but it's very interesting, and I'm very appreciative. Just wanted to, just like I put in my post here, if there's possibility to talk to you one-on-one here, we'd appreciate it.
Okay. Send me an email. I mean, boy, I just can't escape. Every time I try to get out, they pull me back in.
I'm sorry. I sent you my phone number there and my email there. Sorry about that.
No problem. I'm just being funny.
It's wonderful information. I love the individual that gave you the wonderful nutritional. I'm a physician. I'm also a natural physician, natural board certified natural medicine. She is correct, and used the garlic the way she indicated, and golden seal and all that. And then it's a wonderful webinar, and it's a little over my head right now.
I understand, but think of it this way: you being a physician,
you understand science, okay?
Correct. Correct.
Law is exactly the same way, only you're not dealing with medicine or herbs or anything like that. There's a cause and effect associated with everything. All right. That same principle applies in law. Law is scientific. If you learn the principles that that everything rests on first, that's what I'm teaching today. And
Right.
this document right here is what you want to start studying first. Okay, this is on my website. This is a one-page document. Get this, put it on a wall somewhere, and look at it every day. I'm gonna tell you what happened to me when this was first given to me. I didn't know what the hell it was talking about. And but what I used to do, I used to just look at it every day. And then I decided, I said, you know what? I said, I'm gonna look up each one of these words in a Black's Law Dictionary. So I looked up procedural law, remedial law, substantive law, public law, private law. Then I looked up all of these. And slowly, it began to dawn on me. What happened was I was in a law library, and I was reading this right here. And you see down here, law is either public or private. Forgive me, I did not write down the citation for this, but this right here is what changed my world. The reason I wrote that down, that is a quote that I saw in the law library, a Supreme Court justice said. He said, all law is either public or private. That, when I read that, that made me understand everything in the law library.
Right.
Everything.
I'm appreciative, but I don't want to take you away from the webinar. If you could,
you're fine, because I'm about to wrap up.
If it's possible to talk to you one-on-one, I appreciate that very much, and thank you for giving me the opportunity to ask that question.
Okay, no problem, no problem, no problem. Hey, y'all, that's it for me tonight. Y'all know I'm a little under the weather tonight, but I think I gave y'all a full 3 hours. But I apologize for, I'm a little under the weather. I got me some garlic right here. I do. I got it right here. So I got a little, let me show you. I got a little, see right here? Look, is that what you're talking about?
Yeah, exactly. That looks so big.
Yeah, it's too big.
But make sure you. No, I don't think so. It's like everybody's mouth is different, but just make sure you have it, lined up so it's comfortable. It wraps around your jaw, your teeth, your gum. You know what I mean? In other words, the pointy things are sticking out.
Okay. All right.
Before you hang, I just have a dumb question. What happened to the park? What happened to the park? Is it still a park, or did they build houses on it?
Oh, okay. Good question. I want you to go and shepherdize this case, and you will find out, because that's what I did. What happened was they remanded it back. The Supreme Court reversed the decision of the Georgia Supreme Court. They remanded it back, and when it got remanded back, the trust was dissolved, and the park reverted back to the heirs of Senator Bacon's estate. They dissolved the trust, and they got their property back because the trust couldn't be executed. They wouldn't allow it to be executed, so they dissolved it. I think you can find it. Let me see if I can shepherdize it for you real quick.
Oh, you need to go to bed. Suck on your garlic.
Yeah, I do. But that was a good question, though. That was a good question. Let me see. But my point in doing this was to, I wanted you to understand. I was really, really hoping everybody grasped the principle of public and private. That was my point in doing this case. Let me see, Evans versus Newton. See, there's the Georgia Supreme Court right there. See right here, Georgia Supreme Court, and there's the federal Supreme Court. So this might be, yeah, here it is right here. See, this is when it got sent back to the Georgia Supreme Court. So it says the judgment of this court on September 28, 1964
affirming the judgment of the Bibb Superior Court was on January 17, 1966, reversed by the Supreme Court of the United States. In its mandate to this court, it was ordered that the cause be remanded to the Supreme Court of the state of Georgia for further proceedings not inconsistent with the opinion of this court. In response to our request, counsel for the plaintiff in error and counsel for the defendant in error, other than the city of Macon, have filed briefs as to what directions, if any, should be given to the return of this case to the trial court. And let me see if I can go down. It says, under these circumstances, we are of the opinion that the sole purpose for which the trust was created has become impossible to accomplish and has been terminated. Where a trust is expressly created and fails for any cause, the resulting trust is implied for the benefit of the grantor or testator or his heirs. The trial court, in its order, stated that it was not at any time necessary to pass upon the secretary conditions of the trustees of Senator Bacon's estate and intervening heirs as to the failure of the purpose of the trust and its reversion to the Bacon estate. As we view the status of the case in light of the United States Supreme Court decision, direction is given to the court on the return of the case determined and passed upon the condition of the trustees of the Bacon estate and intervening heirs, and such other questions may be properly raised by the parties. The judgment of this court on September 28, 1964 is vacated, and the judgment of the Supreme Court of the United States has made the judgment of this court. And what they did is they viewed it as what? Terminated. All right? Right here it says it. Under these circumstances, we are of the opinion that the sole purpose for which the trust was created has become impossible of the accomplishment and has been terminated. See right there? So this is called shepherdizing. What I'm doing right now, I'm following the case, everything that happened. You see what I'm saying? That's called shepherdizing, to see if it's still good law. It went to the Supreme Court, and then it went back to the Georgia Supreme Court. I think this right here is the first one. This is when the Supreme Court got it first. This is when the Georgia Supreme Court first got it, and then this is where the Supreme Court of the United States got it, and then they remanded it back to the Georgia Supreme Court to change their ruling. So you start here, then you go here, and then you go here, if you want to follow the case in its entirety. Okay, you got that?
Good knowledge. Good knowledge.
Yes, thank you.
You're welcome, because I know y'all, some of y'all are curious as to what happened, and maybe you will continue to research on your own if you're so inclined and improve your, your comprehension skills as it relates to understanding case law and trust in this particular matter. And, there it is for you, showing you the research tools that are at your disposal with Google Scholar and how to research these cases and look up these cases. Was this a pretty good webinar? Did y'all get a lot from this tonight?
Yes, we did. Well, I can say I did.
Absolutely.
Okay. Well, I would appreciate it at the end of this webinar that all of you go to my website at highfrequencyradionetwork.com on the webinar section, and you'll see right here on this, down at the bottom, there's a comment section. I would appreciate it if y'all review this, rate it for me, leave any suggestions or anything like that. I would appreciate it, okay?
Brother Yusuf, you mentioned the jurisdictionary possibly?
Yes, what about it? Oh, yeah, you wanted me to put it in. Yes, I will put a copy of jurisdictionary in the folder for you. Yes, I will do that.
Appreciate you.
Thank you. Thanks.
Okay, with that, I want to thank everybody again. Appreciate it. I will see you tomorrow. We will resume with our reading of the Successful Management Trust book. If you were, I don't know if you know it or not, tonight I did put an additional chapter, 14 pages of the book was included also with this particular webinar. Okay? Peace, everyone. Y'all have a wonderful night, and I will see you tomorrow night. Okay? Peace.